1, 2, 3, go.
Hey YouTubers, this is Guardian Mike, and I have a situation I want to share with you, the short story, and then we can have some discussion. Got a call for a guardian, a need for a petition for guardianship, and it's a situation where the parents are calling, and police are involved. The child has a baby, and is using the baby as a shield in a hostage situation. Police are called. This is an individual who is a child and is mentally ill, has a history of mental illness, and the parents were reluctant to seek a guardian. Probably called and talked to a law office maybe 3 or 4 months ago and abandoned the effort. So as the situation evolved in what I would call a psychosis or a psychotic bloom, where the mental illness is taking over the thoughts of the individual, they begin to want to burn down where they're living at. They have an infant and they hold the infant in their arms. The police arrived and the police treat it as a hostage situation. The infant is being used as a shield, and this is a recipe for disaster. The purpose and what motivated this particular tape is around the country and in the nation. We're seeing a lot of violence, a lot of shooting. When you have a hostage situation, what that means in my mind is a sniper. Police come in, they're going to try to protect that infant, and the individual who has been diagnosed as mentally ill, who has had treatment before, does not have a guardian. So we do not have the protection of a guardian. The person has all their rights and has refused treatment, off their meds, and now we have a crisis that could lead to death. So that's what brought me to this point here. When do you intervene against a loved one and go to court, see a lawyer, seek help to prevent further disaster? And I'm not certain that that's on the radar screen of families, particularly parents, when you have an adult child, and how rapidly things can deteriorate. So I do not want to encourage a rush to justice or a rush to court to get a guardian in every situation. But if you have mental illness, you have a history of mental illness, you have repeat hospitalizations, maybe 3 or 4 or more hospitalizations in a 6-month to a year period, you have that individual who is mentally ill and been hospitalized with an infant, and there has been threats against partners in that person's life or the infant, that's probably time that you need to consult with an attorney, and you need to get help soon and scaffold the individual's life. Because you could lose predictability and lose control. You have the police called. The police don't know the background. They don't know what they're dealing with. They know that there is an infant in the arms of somebody who's threatening to harm, and that's when, in my opinion, they start to think about snipers. They start to think about projecting deadly force to protect an infant. So this is one of those times where I want to share with you that you need to consider at least a consult with somebody who works in this area. And those are my thoughts. Now, is there any questions here? I've got somebody in the audience today.
Yes, Mr. Katarski, could you tell us how the situation ended up being resolved with the hostage situation you were describing?
The police labeled it hostage. They called the parents. This is an adult child of the parents. The parents came down, and the infant in the arms of the mentally ill person was turned over to the grandparents, who was the parents of the sick person, and the individual was arrested and was taken to jail.
Okay.
You know where they ended up in jail? They ended up in a bullpen. Not segregated, not in a medical unit, but they ended up in a bullpen. If you've never been to jail, the bullpen is maybe a room about 20 feet by 20 feet in this county, and you have benches like you'd see. There's no backs on them, and there's maybe 3 or 4 benches. People are handcuffed. They're sitting in that room with their orange jumpsuits in general population, and that's not a good feeling. And if you are already in a mental state of mind where you're not sure what's going on, you may have intervening thoughts. There's nobody there to advocate. There's no label in a lien computer, that's a law enforcement computer, saying this person has been determined mentally ill, has a guardian. That's where they're at, and they're going to be treated generally. And from my standpoint, other inmates could harm them if they're starting to become delusional, or they could harm themselves.
So, how do you think the situation could have come out differently if appropriate steps have been taken to secure guardianship or other probate court remedies and help for this individual?
Well, at a bare minimum, and you do your analysis, is, first of all, a power of attorney. And a power of attorney for somebody's mentally ill has a specific clause in Michigan where if the individual who's mentally ill and who delegates the authority to the parents, in this case, say we have someone in their 20s, and they delegate to their parents and say, listen, I want you to be my agent when I'm incapacitated, and if I revoke that power of attorney, that revocation is not good for 30 days. That way you can get them health treatment maybe at a hospital. That's step one. Step two, when somebody has been under a court-ordered involuntary treatment and that order expires, and it's been a repeat effort to get them treatment, and they expire and they refuse to take their medicine, probably when that individual who's mentally ill, been determined to be a harm to self or others, and already has a prior history of court-ordered involuntary treatment, when they are at that low point, that's when you probably want to get a guardian. Don't wait until they're strong. Don't wait until they're having a good time. You want a guardian in there who can make decisions for them, placement and medical, so that you can prevent the hostage situation. That's my opinion. Step one, at least at a minimum, powers of attorney.
Okay. What should somebody do if they have a loved one who may be in crisis or near crisis, have a mental illness or other medical problem, where they aren't making informed decisions? What should they do if that person isn't cooperative with a power of attorney?
Then they should consult with an attorney, or you obviously can represent yourself. But if they're not cooperating, that's when you you go to court, and the court can delegate the authority, and you have the court that can order matters even against their cooperation. You can also seek in Michigan, you can avoid the guardianship, but you can seek a petition for involuntary treatment. But in my opinion, they kind of are hand in glove. If you've had 2 or 3 attempts to get involuntary treatment, and you've been successful in a couple, and the person repeatedly is in crisis, goes off their meds, I think you're looking at a guardianship.
Should somebody wait until they're sure that a mentally ill person is a danger to themselves or others, or going to hurt people, before they go to probate court to try to get a guardianship or involuntary hospitalization?
In my opinion, that's a difficult and let me repeat the question. Should somebody wait until they're absolutely in a crisis to go to get a guardian or a guardian? In my opinion, the answer is no, because I'm balancing out I'm doing a catastrophic analysis. When they're in crisis in this part of the country, in Michigan, and we're in a particular part of Michigan, you run the risk that they are going to die. You run the risk that they're going to hurt somebody else, and you've lost control and predictability. So you're always balancing a person's individual rights and freedoms, and the system, sadly, is set up to almost where you have to wait for a criminal act to take place before you can get them help. So I am one to be proactive, preemptive, and probably err on the side of a structure and at least get it in front of a judge. That judge will have a doctor take a look at it and have that decision made. So my thought process is early intervention when you have a known mental illness, a repeat offender where they don't take their meds, a history of mental illness where they refuse to take their meds. I think early versus late intervention is better. Particularly when you're in a family situation where they have a spouse or a significant other they're living with, and you have an infant. That's a recipe for disaster.
Absolutely. Any closing thoughts for us today, Mr. Kotarski?
Stay tuned. I'd like to do a part 2. I have not done a lot of planning for this video. As I indicated to you, this is going to be Guardianship 101 that's going to introduce you to these concepts. And I am sharing with you my life as a neighbor, as a friend, as an attorney. I'm sharing with you my life as I live it, and so it'll be more refined. Stay tuned. We will probably explore this topic more in our series 102. But this is the 101. Just want to introduce to you that minimalizing the problem, ignoring the problem is not an answer. I want to put on your map of knowledge that you need to be proactive and have your spouse or whoever is resisting take a look at this video. That's the purpose of this.
Great. Thank you very much, Mr. Katarski.
You're welcome.